Good morning. Good morning. Good morning. Good morning. Hey, Kimmy. Good morning, Kim. Kim, when we finish, I need to talk to you. Good morning, Angie. Good morning, Edna. Good morning, Shannon. Good morning, Demetra. Good morning, Lady Sunshine. Good morning, Alicia. Good morning, Stephanie. I'm gonna just say a couple of good mornings, and I'm gonna, wait till like 3 minutes because I want everybody in here because everybody's like still a little bit asleep. So I'm gonna wait a few more and say good morning to some of you guys in here. Good morning, T girl. Good morning, Sharon. Good morning, Nakia. Good morning, Nakia. Good morning, Derek. Good morning, Lottie Dottie. Lee like the party. Good morning, Riri. So I'm gonna wait a few more minutes because I don't want to, you know how it is. Somebody comes in and be like, what are you reading? What are you talking about? You know, that type of thing. Good morning, PDQ. Good morning, y'all. She tricked us. She got this stuff done. Done. She got that paperwork done. The final brief is done. Good morning, Angel. Good morning, good morning, good morning. She got it done, y'all. Jennifer got it done. Okay, we are about 2 minutes and 41 seconds. Let's just wait. Let's wait a nice number 4 minutes. Nakia, thank you, Nakia. Good morning, Miss Fat. Good morning, Angel. Let's start the ground rule here. I need you guys to hit the like button when you come in. If you haven't hit it yet, go back out, hit the like button. It's 35 of y'all in here. It should be at least 35 likes. Let's do me that favor, right? Because I'm taking the time to get this stuff to you guys, right? So the most precious, wonderful thing that you guys could do is hit that like button when either coming in or going out. I would truly, truly, truly appreciate it because we need this to go out to the in the algorithm, and we need other folks to be able to see some of this. Okay. How about that? Let's not be selfish. Let's just not make it me and myself and I. Let's get the like buttons up. Oh, got it, y'all. Y'all the bomb diggity. I thank y'all. But it's 44 people in here and I got 35 likes. Come on, guys. The ones that's just coming in here, hit the like button. Hey, Lisa. You said low? You said I'm low? Yeah, can y'all hear me, or is it just Lisa that can't hear me? Maybe it's Lisa's connection, because my thing is pretty high. Might be Lisa's connection, not Sylvia's. Thank you, thank you, thank you, thank you. It's just Lisa. Thank you, Derek. Thank you, Alicia. Thank you, Sharon. You can hear me well. Okay, Lisa, I think you probably need to do something with your connection because it's you. It's not me. It's you. It's you, darling, not me. Early bird catches the worm. Go on, Jennifer. Jennifer got that thing in there. They had given her to the 20th, but today's the 19th. It's in there. She sent it in. All right, y'all. Y'all ready? You guys ready? You're good. I hear you loud and clear. Okay, you guys ready? Let's go. Let's get this thing done because we're at 5 minutes and 20 seconds and it's a little bit. All right, let's go. And hopefully the transcript on this thing here will give people the opportunity to know where we start at. So we starting at 5 minutes. And let's start at even 6 minutes. I mean, start even 6 minutes. All right, like buttons hit. And we're going to begin. All right. 5, 4, 3, 2, 1. All right, guys, let's go. 22-1481, 22-1982, Con. United States of Appeal for the Second Circuit, United States of America appellee versus Robert Sylvester Kelly, aka R. Kelly, defendant appellant. On appeal from the United States District Court for the Eastern District of New York, brief for defendant appellant Robert Sylvester Kelly, Jennifer BonJean, Ashley Cohen, BonJean Law Group PLLC, 750 Lexington Avenue, 9th floor, New York, New York, 10022. And the phone number. Table of content. Statement of jurisdiction. 1. Issue presented for review. 2. Statement of the case. 3. Summary of the argument. 21. Argument 26. I or number 1. The government failed to prove defendant guilty of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purposes and where the defendant and the alleged enterprise were indistinct. 26. A. General legal principles. B. No common purpose to engage in a fraudulent or illegal course of action. C. Defendant and the enterprise are not distinct. Page 37. I forgot to give you the numbers. Y'all know it. 2. The government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to Jane. Number 42. A. Insufficient evidence of intent. B. Insufficient evidence of coercion or enticement. 1. May 2015, trip to California, page 48. 2. October 2015, trip to California, 52. The first one was 48. Number 3, the government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to faith, 54. A. Insufficient evidence of intent, 54. B. Insufficient evidence of coercion or enticement, 56. C. New York Penal Law 120.20, reckless endangerment, 58. D. New York Public Health Law 2307, page 61. Number 4, because New York Public Health Law 2307 is unconstitutionally vague, defendant's Mann Act conviction predicated on that law must be vacated, 63. Number 5, defendant's Mann Act conviction predicated on a violation of California Health and Safety Code 120290 must be vacated because the government charged defendant with a repealed version of the statute that was unconstitutionally vague, 63. Number 6, the government failed to prove defendant guilty of forced labor of Geronda and Faith based on an isolated sex act that neither victim alleged was false, 70. Number 7, defendant was denied a fair and impartial jury where several of the seated jury admitted that they prejudged, my nose is itching. Sorry about that. They prejudged the defendant's guilt and trial counsel provided ineffective assistance of counsel when he failed to move to disqualify patently unqualified jurors. 75. Number 8, defendant was denied a fair trial where the government swapped the jury with excessive bad act evidence, including testimony from 7 additional witnesses who detailed defendant unusual and graphic sexual activity, his history of transmitted herpes to his sexual partner, his abusive conduct towards his girlfriend, and even audio and video recording in this conduct with women and men, some of whom never testified. Whoa! A, excessive STD evidence. B, evidence concerning sexual relationship with Aaliyah. Ooh, child. C, testimony from Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex, 92. D, admission of graphic video and audio recording, 95. Number 9. The district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government's evidence, 96. A, Jane, 96. Stephanie, 101. B, sorry. Number 10, the district court lacked authority to order a BOP to overturn monies seized from the defendant's trust to the clerk of court for future restitution payment, 103. And lastly, conclusion, 106. All right, guys, you guys ready? And here's the table of authority, which has all these different cases. I'm not going to read these cases. Y'all could just, I'm going to slowly go up so you guys can see these cases. It's a lot of them. All right, I'm about to hit the stop. I'm about to stop because I'm looking at my phone. I only see 35 likes, and I'm about to stop because if you guys can't appreciate what I'm doing, I need to stop because 95 of y'all in here, and it's only 35 likes, and that's not nice. I'm not doing this with y'all this morning. Not doing it with y'all because really, this is ridiculous. Call me unprofessional. That's fine. But I got up this morning to do this for you guys. The least you could do is hit the like button. I'm not doing it. Not today. Not this morning. It's almost 100 people in this chat. 99. You know what? I can just go ahead on to the back and do it with my members. And then my members hit the like buttons and I'll be okay. All right, I'm gonna give y'all about 3 minutes. If nobody hit the like, if I don't get the number that I want, I'm just gonna go ahead and go to the members only. I'm not joking. And y'all wait till somebody else come up and read it to y'all. Good morning, Denver. Denver, did you hit the like button? Thank you, Trissy, for the Cash App. I just think it's a very selfish thing that you can do. Somebody getting up, you didn't have to pay for these transcript. I mean this brief. And the thing all I ask is for you to hit the like button on what you do. But you're here. That's a sad thing, you're here. Because see if you wasn't here. No, Precious. He's not. He's in Chicago. I'll start at 95, Kim. Let me know when it gets to 95 likes. And if the numbers keep going up in the chat, the numbers should be going up in the likes as well. Those that are coming in, go out, hit the like button, come back. All right, Kim, I'm going to go ahead. Kim is in 95. Okay. Thank you, Nakia. Thank you, Nakia. Nakia, she cash at me as well. Thank you, Nakia. Nakia must be feeling me this morning because I'm not having it. Not this morning. I'm not. All right, y'all ready? We got 95. Kim, did you say 95? Yeah, I'm looking at Kim. Kim didn't say anything, so I have to go by what my Kim said. Oh, she did say 95. Okay. Kim says 95. I know some of you guys already have 95 up, but I follow hers because hers and I are in sync with each other. All right. Kim says 99. All right. And hopefully the numbers are still going because, y'all, this is not like you're not the one reading it. You're not the one. You didn't have to pay for it. So my suggestion for you is to be a little kind and help your sister out to get this into the algorithm. Hit the like button when you come in. If you have not hit it. Make sure you hit it. Take a moment, just go back out, hit the like button, and we'll be done. Sounds good to me? Sounds good to you guys? And I thank to every single one of you guys who did hit the like button. I do appreciate. Sorry I had to do this, but this is my time as well. If I'm just getting up in the morning to do this, the least you could do is hit the like button. It's called common courtesy. All right, let's go. And thank you, Teresi and Nakia for the Cash App. All right, let's go. Other authority, the New York Penal Code, codes of California, and so on. Statement of jurisdiction. A jury returned a verdict, finding defendant guilty of all charges in the government's third superseding indictment on September 27, 2021. ED 238. You know what, guys? The numbers and things like that. I won't be reading the code. I might read the name of the case, but I'm not going to read all these other codes, okay? Because I don't want it to slow us down any longer. All right. Let's go. Don't forget, hit the like button. We don't want to stop again, okay? Defendant was sentenced to a term of 30 years imprisonment on June 29, 2022. Judgment was entered on June 30th, 2022. A timely notice of appeal was filed on July 22nd, 2022. After a subsequent restitution hearing held on September 28, 2022, the district court entered a restitution order on November 8, 2022. Defendant filed an amendment notice of appeal on November 22, 2022. The amended judgment was entered on December 7, 2022. On September 9, 2022, the district court judge entered an order directing the Bureau of Prison to overturn money it seized from defendant's inmate trust account to the clerk of the court. Defendant filed a notice of appeal for that order on September 9, 2022. The United States of Appeal for the Second Circuit has jurisdiction over these matters pursuant to 28 U.S.C. 1291. Let's read the citation, guys. We are going to read the citation because they're a very important part of this brief. Number one, citations. Cites to the district court docket will be as follows. Cites to the special appendix will be as follows. Cites to the appendix will be as follows. Volume number of, I'm not going to read those things. Cite to the sealed appendix will be as follows. So there's a sealed appendix, y'all. Cite to the trial transcript not contained in the appendix are as follows. Cite to the government exhibit are as follows. Issue presented for review. Now, this is the meat and potatoes of this, y'all. This is the meat and potatoes. All right, hold on. So there is 30 people who just came in here and didn't hit a like or anything, and they're in here. This nonsense got to stop, people. You know what's going to happen? If I have to stop one more time, I'm just going to end this live and just go to the membership. That's what I'm going to do. Thank you, Ashley, for the Cash App. Thank you, Lady Coach Shane, for the Cash App. Appreciate you guys. Thank you for those who just hit the like, the last 3 people. Thank you. All right, number one. Issue presented for review. Remember, this is the meat and potato, guys, okay? Number 1, whether the government failed to prove defendant guilt of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose, and where the defendant and the alleged enterprise were indistinct. Number 2, whether the government failed to prove defendant guilty of, thank you, Vicky, guilty of voiding the Mann Act as to Jane. Guys, those who are giving me Cash App, I'm going to wait to thank you guys at the end if you don't mind. I just don't want to interrupt in between reading. And I appreciate you guys, so don't think I'm ignoring you giving the Cash App. I just want to get through this, okay? Thank you, thank you for giving the cash app. But let me go ahead and continue. Number 3, whether the government failed to prove defendant guilt of violating the Mann Act as to faith. Number 4, whether the New York Public Health Law 2307 is unconstitutionally vague, such that the defendant's Mann Act conviction predicated on that law must be vacated. Number 5, whether the defendant's Mann Act conviction predicated on a violation of the California Health and Safety Code 120290 must be vacated because the government charged the defendant with a repealed version of the statute that was unconstitutionally vague. Number 6, whether the government failed to prove defendant guilt of forced labor of Geronda and Faith based on an isolated sex act that did not constitute labor or service, and that neither victim was forced. Excuse me. Number 7, whether defendant was denied a fair and impartial jury where 4 of the seated jurors admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance of counsel when they failed to move to disqualify that patently unqualified juror or otherwise conduct a meaningful voir dire of prospective juror. Number 8, whether defendant was denied a fair trial where the government swapped the jury with excessive bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activity, his history of transmitted herpes to his sexual partner, his abusive behavior towards his girlfriend, and both audio and video recording of this conduct with women and men, some of whom never testified. Number 9, whether the district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government's evidence. Number 10, whether the district court lacked authorities to order the BOP to turn over money seized from defendant trust account to the court of clerk for future restitution payment. Statement of case. The defendant, an international renowned recording artist, was charged with leading a racketeering influence and corrupt organization, RICO, enterprise between 1994 and 2018, comprised of individuals whose subjective was to promote defendants' music and to recruit women and girls for illegal sexual activity with defendant and to produce pornography and child pornography. Defendant was separately charged with various Mann Act violations stemming from conduct in 2015 related to Jane and 2018 related to Faith. After a 6-week jury trial, defendant was convicted of all counts of the 3rd superseding indictment. He was later sentenced to 30 years imprisonment. Through new counsel, defendant filed excessive post-trial motion pursuant to Federal Rule Criminal Procedure 29 and 33 that were denied by the district court in a 103-page memorandum decision and order. Remember, guys, I'm going to put a pin there. Remember, I was reading that to you guys the other day. I never finished it, but remember I told you that's where it was, the meat and potatoes was? I was showing y'all the right track, what she was going to argue from, but I never got a chance to complete it. But this is it. Remember I told you the 103 pages of memorandum decision and order. I'm not even an attorney, but I knew where to go. Ping. All right. Defendant includes a concise statement of the case, setting out the facts relevant to the issues raised in this brief, and also refers this court to the district court's detailed factual background presented in the light most favorable to government's content contained in its order. Pretrial motion. Okay, let's read the second footnote. On September 14, 2022, defendant was convicted in the Northern District of Illinois with 3 counts of production of child pornography and 3 enticement count. He was acquitted of obstruction of justice, receiving child pornography, and 2 enticed count. C, United States versus Kelly, and then the case number there. Defendant was sentenced to 20 years imprisonment, ordered to run concurrent in the sentence in the instant case, with the exception of 1 year, which was ordered to run consecutive. All charges brought by the state of Illinois were subsequently dismissed. Defendant has an open pending criminal case in the state of Minnesota. Kim, how do the numbers look like? What's the numbers look like, Kim? What's the likes look like, Kim? Okay. Thank you, guys. That's hitting the like button. I appreciate y'all. Defendant unsuccessfully moved to dismiss the RICO count pretrial, arguing that the government failed to sufficiently plead a RICO enterprise. Defendant also moved to dismiss as unconstitutional those Mann Act charges premises on a violation of the New York Public Health Code Section 2307. The district court denies the motion in a written order. On July 23, 2021, the government filed a 55-page motion seeking to admit extensive prior bad act evidence. On July 30th, 2021, defendant's counsel filed a written objection to the government's motion and filed a supplement response on August 6, 2021. Man, I'm telling you, I'm good. I went exactly to those things. Remember? Okay, let me shut up. The district court issued a ruling from the bench followed by a written order largely granting the government's motion. Throughout trial, defense counsel asked the court to reconsider some of its ruling regarding the admission of bad acts evidence, mostly unsuccessful. Jury selection. Because of extraordinary pretrial publicity, the district court directed these parties to submit a joint proposed jury questionnaire to be completed by prospective jurors. The parties reviewed the questionnaire to determine whether they agreed to dismiss some of the jurors for cause. The district court conducted an oral voir dire as to the remaining prospective juror, affording the parties the opportunity to submit additional questions to probe their qualification to serve as jurors. Numerous seated jurors were either familiar with the accusation that the defendant had a history of sexual abusing underage girls, had previously faced legal problems, and or had seen the highly unflattering docuseries Surviving R. Kelly. Number 3, there's a third footnote on that, in which several government witnesses had appeared. Defense counsel did not move to disqualify jurors who admitted they had prejudged defendant's guilt or had gathered knowledge about the case from other sources. Uh-oh. All right. Defendant was largely excluded from the voir dire process. That in itself right here is a violation, y'all. Right here. This right here is a big violation. Because I'm gonna stop. Because it's gonna be long enough. Let me not read that part. All right. Defendant was largely excluded from the voir dire process. Now, C. Complainant's testimony. The third superseding indictment charged defendant with various racketeering acts related to sexual misconduct committed against 6 women: Inta Aaliyah, Geronda, Jane Doe number 4, Jane Doe number 5, Faith, Jane Doe number 6. Number 1, Geronda. Y'all ready, guys? All right, Geronda. In 2008, Geronda was a super fan of the defendant and met him as she walked alongside of him as he left court. She told him she was a fan. Let's see, read the footnotes. Surviving R. Kelly was a Lifetime docuseries that detailed sexual abuse allegation against the defendant. It aired over 3 nights from January 3rd to January 5th, 2019. In its premiere episode, it was Lifetime's highest rating program in more than 2 years, with 2 million viewers, with totaling 2 million viewers. All right, there's a Lifetime right there. All right, here we go. In 2009, Geronda and her friend received an invitation to a party at defendant's home by one of defendant's employees. Geronda spoke with defendant at the party and exchanged phone numbers. She falsely told him she was 19. A few days later, the defendant invited Geronda back to his house where they engaged in sexual contact. According to Geronda, she felt uncomfortable and privately confessed to the defendant that she was actually 16 years old. The defendant told her to continue to tell everyone she was 19. Geronda did not testify that she told anyone other than the defendant that she was 16. Geronda continued visiting the defendant and having sex with him for approximately 8 months. On January 23rd, 2010, Geronda testified that that defendant slapped her and choked her for disrespecting him. Defendant went into the VIP room with Geronda where he instructed her to perform oral sex on him, which she did. Geronda left defendant's studio after this incident and did not return. Thereafter, she sued the defendant. Jane. Number 2, Jane. Jane and her parents attended one of defendant's concert in Orlando, Florida in April 2015. Jane was 17 years old. Jane claims that she made eye contact and connected with defendant while he was performing and danced on the stage during the performance. Someone provided Jane with defendant's number after the show. Jane attempted to call the number but could not reach the defendant. Jane's mother began texting the defendant pretending to be Jane. Over the course of 2 days, Jane eventually spoke to the defendant and falsely told him she was 18 years of age. Jane went to the defendant Jane met the defendant at his hotel room in Orlando, where they engaged in sexual contact. At one point, the police arrived, and Jane reassured the defendant that she was 18. After checking Jane's identification and confirming that she was 18, the police left. Thereafter, defendant invited Jane to meet him in Los Angeles, where he was performing. With her mother's consent and encouragement, Jane met defendant in California and traveled with him while he was touring. After his final performance in Stockton, they had sexual intercourse for the first time. Jane moved to Chicago the summer of 2015 to stay with the defendant. When the defendant learned she was 17 years old, he sent her home to Florida. Let's read the table of contents. The age of consent in Illinois is 17. Okay. With the consent of her parents, Jane returned to Chicago to live with the defendant. In September and October 2015, she toured with him again in the state of California. Jane turned 18 in December 2015. Hold on, y'all. I had to drink my water, sorry. Sorry about that, guys. Jane and defendant continue a relationship for 5 years. Defendant had other living girlfriends. Jane characterized the relationship as abusive at time and detailed that defendant had many rules and would punish her and his other girlfriend with spanking if they broke the rules. Faith met the defendant on March 2017. At a concert in San Antonio, Texas, when she was 19 years old. She and her sisters were invited to an after party where she met the defendant. He gave her his phone number. Faith and defendant began texting regularly. Defendant and Faith met each other in person 5 times and had sexual encounter during those occasions. Defendant arranged for Faith to travel to New York on 2 occasions, in May and February 2018, where they engaged in sexual activity. Faith also traveled to Los Angeles on 1 occasion in January 2018, where, according to Faith, she saw a gun in his studio that unnerved her. At the defendant's direction, the defendant performed oral sex. The defendant performed oral sex on the defendant. She made a mistake there, y'all. The defendant performed oral sex on the defendant. I guess she meant Faith performed. Okay. D. Defendant's former employees. The government presented testimony from roughly 8 former employees of the defendant. One of these individuals was surprised. None of these individuals were charged as members of the enterprise. 1. Demetrius Smith, friend and personal assistant, 1984 to 1994. How we doing, Kim, with the likes? 153. Okay, thank you. All right. Demetrius Smith, friend and personal assistant from 1984 to 1994. Smith met defendant as a teenager when he was still attending high school and singing in the subways. In the middle, in mid, hold on a second. Let me check this thing out because that's not what I see. Hold on, y'all. I'm checking this out. Let me see. Hit the like button, guys. Those that are coming in, hit the like button. All right. Smith met defendant as a teenager when he was still attending high school and singing in subways in the mid 1980s. Smith was first a friend and a mentor to the defendant, and then began working as his personal assistant when defendant received his first record deal in 1988 or 1989. Smith worked off and on for the defendant as personal assistant until 1994. Smith's responsibility included assisting the defendant in these things he needed and with scheduling. Smith testified that defendant met Aaliyah through his manager, Barry Hankerson, who was Aaliyah's uncle. Smith testified that from his perspective, their relationship was strictly about music, and that he never saw defendant take Aaliyah out by herself. Smith did concede that there were short periods of time when defendant might be alone with Aaliyah. There were times when he thought defendant and Aaliyah were overly playful and too friendly, and he asked defendant if he was messing with Aaliyah, to which the defendant always responded no. Smith erased those concerns a few times, but only learned that the relationship was more than platonic in 1994 when it was believed that Aaliyah might be pregnant. Number 2, Tony Navarro, runner and sound engineer from 2007 through 2009. Anthony Navarro worked as a sound engineer in defendant's studio for 2.5 years. Navarro understood it was an entry position. Now, if she messed up there, should be would include such duties as cleaning, doing food runs, and driving guests around. Navarro testified that numerous people came through the studio, including different girlfriends of the defendant. One of his responsibilities was to drive the girlfriends where they needed to go. He was instructed to speak to the defendant's guest, not to speak to the defendant's guests. Navarro explained that defendant's guests were generally required to ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unoccupied. Sometimes these guests would stay in the studio for extended time, but could leave if they wanted to. Navarro did not know the details of why the female guests visited defendant. Navarro picked up a female guest who appeared to be underage. They appeared to be around his age, in their 20s. Oh, sorry. He said Navarro never, that's what I said, right? Never picked up a female guest who appeared to be underage. They appeared to be around his age, in their 30s. Navarro had never seen defendant engage in sexual activities in his home or in his studio. Navarro went on tour with the defendant and observed that invite observed that invites would be distributed to attendees at the party for the after party. Sorry, for the after party. Sometimes defendant's phone number would be on the invites. At time, he would see defendant's phone number distributed to people at the mall or at the restaurant. Navarro never saw underage girls backstage. Navarro recalled that identification was checked before people could go backstage, but he could not recall whether people had to be 18 or 21. Number 3, Tom Arnold. Tom Arnold worked for defendant from 1998 to 2011. He started as a runner and eventually became his studio manager and road manager. One of Arnold's responsibilities working for the defendant was to provide transportation to his guests, which could include men with whom defendant played basketball, a musician, and his female guests. If defendant wanted Arnold to transport a guest somewhere, defendant could tell him directly. Would tell him directly. Or someone from defendant would make the request. Arnold testified that the protocol for driving guests from one location to another was to open the door for them, turn the rearview mirror up, and turn the radio on a reasonable volume. Arnold understood that turning the rearview mirror up was to avoid eye contact with defendant's female guests and to ensure their privacy. Guests at the studio were required to sign confidential agreement that prohibited guests from recording or taking photos. Staff would either take Polaroid photos of guests or copy their identification to confirm the identity of the person signing the confidentiality agreement. The policy of having studio guests with confidentiality agreements originated from defendant's business manager and lawyer. Arnold generally had no interaction with the defendant's female guests. If a guest in the studio was hungry, they would call the front desk and Arnold would arrange to get the food with petty cash that was at the reception area. If a guest wanted to move from one location in the studio to another, Arnold would get permission to escort the guests. If a guest wanted to speak with the defendant, Arnold would relay the message to the defendant. Arnold explained that generally guests would not be able to roam defendant's studio and home freely, but would ask for permission to go from one point of the studio to another. Arnold testified that there were instances when he would provide defendant's phone number to a woman, not normally in a concert setting, but in a after party or party at a club or possibly at a mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identification was checked to ensure that. Arnold did not testify that he provided defendant's number to any woman underage. Arnold testified that sometimes arranged travel for defendant female guests until they began using a professional travel company. Arnold would obtain the guest identifications to arrange their travel. Arnold did not testify that he booked travel for any underage female guests. Number 4, Suzette and Alizette Mayweather, personal assistants in 2016. Susan and Alizette worked as personal assistant for the defendant. Suzette worked for defendant between October 2015 and February 2017. Alizette worked for the defendant between late 2015 and June 2016. Their job responsibility were to attend to anything he needed, running errands, shopping, taking care of laundry, arranging accommodation for guests, female and male, coming into town, and booking airfare. Suzette and Alizette testified that the defendant had several lived-in girlfriends during this period of time. They testified that the defendant was controlling his girlfriend, expected them to follow certain rules, dress down in baggy clothes, and suspected he slapped or spanked them previously. On occasion, the sisters expressed concern among themselves about defendant's mistreatment of Jane. The sisters denied that they took any action at any time to assist defendant in procuring girls or women. Number 5, Diane Copeland, personal assistant, executive assistant, interimly from 2005 to 2018. Copeland began working for the defendant in 2008 or 2005 as a personal assistant and worked off and on for him until 2018. Her responsibilities were largely household in the beginning, tending to housekeeping and nannies and making sure they were paid. Later on, Copeland would do administrative jobs like answering phone, maintaining defendant's schedule, and tending to defendant's guests, which could be anyone from a record label executive to a personal guest. Copeland would make hotel and travel arrangement for defendant, his entourage, and his girlfriends. Copeland would sometimes carry defendant's backpack, but she never went through it. She did see an iPad in his backpack once. During her last stint of employment with defendant, one of Copeland's responsibilities was to help him get control of his finances. Defendant has difficulty reading and writing. He had no control over his bank accounts, did not even know his social security number, did not even know where his loyalties was going. The defendant instituted rules for guests on his properties, namely to knock before entering a room and not to roam around the property unsupervised. These rules applied to everyone and were actually initiated by his wife when she lived on the property. Copeland acknowledged that defendant's girlfriend Copeland acknowledged that the defendant's girlfriend also allowed defendant followed defendant's rule to wear baggy clothes and not to interact with other men in the public. Defendant had girlfriends who stayed at his property sometime for extended periods of time. Some girlfriends lived in defendant's home while others did not. They were free to leave if they wanted to. Copeland never attempted to stop any defendant's girlfriend from leaving his property. Defendant never asked Copeland to recruit women for him, nor did she even hear him ask any other employee to recruit women for him. Copeland never saw defendant attempted to prevent any woman from leaving his home. She never saw defendant lock any of his girlfriend in a room. And he never asked her to confine any of his girlfriends. Defendant's girlfriends had constant access to food, and assistance to help them with anything they wanted. Nicholas William, intern and runner, 2003. Williams worked for the defendant for a year in 2003 when he was 19 years old. He described the environment as a hostile work environment and was disappointed when that he disappointed that was not to use the audio equipment and was disappointed that was not to what? Disappointed that was not able to use the audio equipment. Different type of people visit defendant at the studio, ranges from professional artists, musicians, actor, to whom he was doing projects, personal training, and some of his entourage and female guests. William noticed that defendant's female guests at the studio were young. William was instructed not to interact with the female guests. Number 7, Cheryl Mack, Executive Assistant, 2014 through 2015. Mack met defendant in 2005 when she was working as a talent manager in the industry. She reconnected with the defendant in 2013 through another record executive and began working as defendant's executive assistant in 2014. Mack managed defendant's calendar and worked on projects with him. She also arranged travel for his guests and entourage. Mack would arrange travel as requested by the defendant and use company credit card to book necessary reservations. She used a company known as Preferred Travel to make most reservations. Mack was prohibited from socializing with defendant's guests. Mack received a text message from Jane on April 2015 asking her to book travel arrangement to California for Jane, which Mack did. Mack later met Jane in the lobby of the Mandalay Bay Hotel in Las Vegas, where she was checking into a hotel room. Mack also saw Jane in Kelly's dressing room at a venue in Connecticut where he was performing. She was there with several other individuals, but eventually left when Kelly began massaging Jane's leg because it made her feel uncomfortable. Mack quit the following day. E. Other bad act evidence. I'm sorry. Okay. Over the defendant's objection, the district court permitted the government to admit testimony about defendant uncharged sexual behavior with at least 8 other individuals, including testimony from Angela, Addie, Kate, Alexis, Louis, Alex, and Anna. The district's court order details the testimony of those bad act witnesses. The permitted testimony from numerous witnesses and through medical documentation, other defendants' history contacting sexual transmitted diseases, including herpes and his alleged transmission of herpes to women. Other than any complainant. The district court allowed the introduction of evidence related to the defendant's alleged mistreatment of employee, including docking their pay for violating his policies and rules. The district court permitted the jury to hear audio recording of defendant's alleged verbal and physical assault of his girlfriends unrelated to the charged offenses. The district court further permitted several video recording of graphic sexual encounter, including sexual contact between Alex, Dominique, and the defendant. 2. Defendant spanking a naked Anna and calling her insulting name. 3. Anna spreading feces on her naked body. On her own naked body. Defendant filed a motion for a new trial based on inter alia, but the court's admission of excessive, cultivated, and highly prejudicial other bad act evidence. The district court denied the motion. Verdict and sentencing. The jury returned a verdict finding defendant guilty of all counts of the indictment. The jury acquitted the defendant of racketeering counts in connection with claims made by Sonia. On June 29, 2020, the district court sentenced the defendant to a term of 30 years imprisonment and imposed court fee and costs. The court deferred a ruling on restitution. Seizure of defendant's trust account, I'm sorry, I should have did it the opposite way. Say G first and then what it is. Sorry, guys. I'm thinking ahead of time. On August 4th, 2022, at the government's direction, the Bureau of Prison, BOP, confiscated $27,824.24 of monies from the defendant's trust account. The government then filed a motion with the district court for an order directing the BOP to deposit the funds with the court of clerk. Defendant objected to the seizure and any overturned order on the grounds of BOP impermissibly confiscated. I can't get tongue-tied. You know it. Okay. I don't know why my brain's not working with that word right now. Confiscated the funds, and the government lacked authority to seize the funds where no default was entered. No restraining order was in place, and restitution had not even been ordered in the case. The district court allowed the government's motion. Restitution. The district court conducted a restitution hearing and awarded Jane $281,168.18 for medication Valtrex to treat genital herpes for the rest of her life. The district court also ordered defendant to pay Stephanie $78,981.72 in restitution, primarily to compensate her for medication to treat genital herpes that Stephanie claims was transmitted transmitted to her by the defendant. Defendant objection to the court's calculation of these amounts were: the government offered no evidence that Jane and Stephanie were receiving suppressive treatment. Suppressive treatment with Valtrex. Yeah, I'm sorry, but my glasses, I have like diabetes, and sometimes I get blurry, so I have to come back and find, because it looked like there was 3 P's on here. Sorry. Suppressive treatment with Valtrex. The brand name prescription for Valacyclovir. Well, I don't know how to say that word. And offered no explanation why compensation should include the monthly cost of Valtrex, which was nearly 40 times more expensive than Valtrex. valacyclovir, the generic version of the drug. Defendant objection were overruled. Summary of argument. All right, guys, we're gonna get to the nitty-gritty of the argument. Hold on a second. I need to take a break for a minute. I need to drink some water. All right, let me get back to reading this. Summary of argument. In Fitzgerald versus Chrysler Corp., Chief Judge Posner cautioned that where a statute is broadly worded in order to prevent loopholes from being drilled in it by ingenious lawyers, there is a danger of it being applied to situation absurd, remote from the concern of the statute framers. Such is the case here, where the government misused both the racketeering influenced and corrupt organization statute RICO and the Mann Act in a manner never previously conceived or carried out. Galvanizing by an influential social movement determined to punish centuries of men misbehavior through symbolic prosecution of high-profile men. The government brought a RICO prosecution against the defendant that was absurdly remote from the drafters' intent, stretching the liberal construction cause well beyond the intent of Congress. The government constructed a RICO theory designed not to effectuate the purpose of the RICO statute, but to prosecute the defendant for alleged misdeed going back decades without pesky statute of limitation obstacles. In the end, the government failed to prove the offense of racketeering where evidence of a RICO enterprise was non-existent. The government's evidence failed to show a collective of individuals who shared any common purpose other than to promote defendants' music. At best, the government demonstrated that the defendant used an unwitting, low-level employee to carry out an anodyne task that arguably facilitated his sexual need, but who had no knowledge, intent, or objective to promote his illegal sexual activity. Adding to its long history of celebrity Mann Act prosecutions, the government charged defendant with violating federal law by arranging Jane and Faith travel to other states, California and New York, to attend his concerts with the purpose of violating public health law, namely by exposing them to herpes during sexual intercourse. Neither Jane nor Faith were actually infected with herpes during these travel because the government could not, as a matter of law, prove that a significant and motivating factor for the defendant's transportation of Jane and Faith was to expose them in herpes in violation to the state public laws. The conviction cannot be sustained. There are more problems with the government's creative charging approach. For one, the California Public Health Code that the government contends defendant violated, Cal Health Safety Code 120290, was repealed by the California legislature, and it was inoperative at the time of the defendant's prosecution. Further, both California Health Safety Code 120290 as charged and New York Public Health Law 2307, which intend to criminalize exposure to a communicable disease, are unconstitutionally vague, where a person of ordinary intelligence would have no notice of what the statute prohibits. And as this case so aptly demonstrates, these statutes encourage arbitrary and discriminatory enforcement. Defendant may be the only person in history who has been charged with violating the Federal Mann Act based on an alleged misdemeanor infraction of state public health law. He is decidedly the only person who has been charged with violating these laws without having actually infected the alleged victim with an infectious disease. The government's proof problem extend to its forced labor charges. Evidency is clear. Evidency is clear. Intent to make federal law coextensive with the state law. The government charges defendant with violating the forced labor statute because on an isolated occasion, he instructed or directed Johanna and Faith to perform an act of oral sex on him, where an isolated act is neither a labor or service, and neither women testified that the defendant forced the sex act. The government failed to prove violation of the federal forced labor law. Sufficiency of the evidence aside, the defendant is entitled to a new trial where the record shows that a minimum 4 of the seated jurors, 3, 4, 5, and 12, were not qualified to serve. Two of whom watched the inflammatory tabloid docuseries Surviving R. Kelly. Trial counsel's performance was objectively unreasonable when he failed to move his disqualified, patently unqualified juror and failed to conduct any meaningful voir dire of prospective juror who expressed their prejudgment of the case. Defendant was prejudiced by his counsel's substandard performance, where it resulted in the seating of at least 4 jurors who were actually biased and could not act with impartiality. There is more. Defendant's trial was engulfed by irrelevant and excessive bad act evidence that added little to the jury's assessment of whether defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly with uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government smuggled in a mass of preponderant conduct under the guise that the evidence demonstrated means and method of non-existent enterprise. This case was not about an enterprise. It was about the conduct of one man who the government searched to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible preponderancy evidence because defendant was forced to defend against dozens of uncharged claims of abuse and sexual misbehavior. Much of it lawful, abiding, unpalatable for some. Defendant was stripped of the presumption of innocence and denied a fair trial. Lastly, the district court abused its discretion in granting Jane nearly $300,000 in restitution and Stephanie $50,000 for lifetime supply of Valtrex for herpes treatment. Where the government failed to establish that the women were infected with herpes as a result of any charged conduct, that either of them are treated with a suppressive regimen of Valtrex and or actually, sorry, that just disturbed me, where and or actually treated with Valtrex rather than Valaxacolor, whatever that one is, the generic version of Valtrex, which is a fraction of the cost of Valtrex. The government failed to offer sufficient evidence to justify the exceptional restitution award. In short, the district court abused the purpose of restitution statute and granted Jane a windfall reward for costs that she has never incurred or will incur, seemingly to punish the defendant. It is in its final push to punish the defendant, the district court abused its discretion when it ordered the Bureau of Prison to overturn $27,000 of seized money from the defendant's inmate trust account for use against in future restitution award without any showing that the defendant had defaulted or failed to live up to his payment obligation. Defendant's conviction must be reversed, and in the alternate, a new trial be granted. Argument. All right, let me see what you guys are doing. Hold on. All right, we're at page. We got a long way to go, baby. We got a long way to go. Woo! Help a sister out, Father God. Give me strength. The government failed to prove defendant's guilt of racketeering where the record is devoid of evidence of an enterprise comprised of members who shared a common illegal or fraudulent purpose and where the defendant and the alleged enterprise were distinct. Ignoring the distinctly economic legislative history of the RICO statute, the government brought a RICO prosecution against the defendant not to remedy the widespread criminal activity of the enterprise, but to punish one man who alleges crime could no longer be prosecuted by state or local agency. Under the guise of the Liberty Construction cause, the government manufactured an ill-fitted RICO theory that was unsupported by the evidence. To be sure, prosecutors have used RICO in a wide variety of circumstances, but the Liberty Construction clause is not an invitation to apply RICO to purpose proposed by Congress. never attended. Reeves versus Ernest and Young. In its rush to indict public enemy number one, hey, hold on, y'all. No, she didn't say that, y'all. All right, Jennifer. Okay, we got you, Jen. She said, in its rush to indict public enemy number one of the Me Too movement, the government stretched the statute beyond its limit, applying it under circumstance leagues removed from statute purpose. Accordingly, when the time came to prove its RICO charges, the government failed at the fundamental task of establishing an enterprise. To convict a defendant of racketeering, the government must prove at a minimum the existence of an enterprise and a related pattern of racketeering activity. United States versus Bakshunia. Y'all, please excuse me for my enunciation for stuff, because, remember, your girl used to be a foreigner, so. All right. Citing United States versus Turkett, viewing the evidence in the light of favorable to the government and drawing an inference in its favor, this court must vacate defendant conviction for racketeering where the government's evidence of a RICO enterprise was insufficient. United States versus Mengia. A. General legal principle. An enterprise include individual, partnership, corporation, association, and other legal entity, and any union or group of individuals associated in fact, although not a legal entity. 18 U.S.C. 1961, the United States Supreme Court has defined a RICO enterprise as a group of persons associated together for a common purpose of engaging in a course of conduct. Turkett. An enterprise is demonstrated by evidence of an ongoing organization, formal or informal, by evidence that the various associates function as a continuing unit. First Capital Asset Management, Inc. versus Santon Wood, Inc. For an association of individuals to constitute an enterprise, the individuals must share common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purpose. The enterprise purpose must be common to all of its members. Stein versus Worldwide Plumbing Supplement Inc. Supply Inc. Also see Crab House of Douglaston versus Newsday. The enterprise is neither the individual defendant nor the pattern of racketeering activity. Rather, it is an entity separate and apart from the pattern of activity in which it engaged and must be alleged and proved separately. However, there must be a nexus between the enterprise and the racketeering activity that is being conducted. United States versus Delestio. Against this legal backdrop and taking the evidence in the sight most favorable to the government failed to prove a RICO enterprise. Assuming arguendo, the government's evidence was sufficient to establish that the defendant committed various sexual offenses between 1994 and 2018. Its evidence did not show that those offenses were committed as part of an enterprise. Specifically, the government's failure to demonstrate a fraudulent or illegal common purpose of the enterprise distinct from the defendant or his racketeering activity was fatal to its RICO theories, notwithstanding the jury's verdict. B. No common purpose to engage in fraudulent or illegal course of action. In its third superseding indictment, the government alleged inter alia that the defendant, individual he employed, and member of his entourage constituted a group of individuals associated, in fact, who function as a continuing unit for the common purpose of promoting defendant's music and brand and to recruit women and girls in illegal sexual activity with defendant to produce pornography and child pornography. Defendant does not dispute that during his 25 years recording career, he maintained a production company that employed dozens of people. Defendant's business was no different from any other business in the music industry and elsewhere. Typically of a hugely famous recording artist. Defendant employed managers, accountants, engineers, security personnel, drivers, runners, and personal assistants. Defendant concedes that people on his payrolls are in his so-called entourage generally shared a common purpose of promoting his music. But the evidence failed to show that his employees shared a common purpose to recruit women and girls to engage in illegal sexual activity with the defendant or in the publication of child pornography. Out of the gate, this RICO prosecution was suspected where the only person named in the indictment was defendant. While the government is under no obligation to indict every member of a RICO enterprise, if the government lacks evidence to indict any other member of the alleged enterprise, it is a good sign that no RICO enterprise exists. The government banded about the buzzword of a legitimate RICO prosecution, quick to label anyone in the defendant's orbit as part of his inner circle, but came up short on actual evidence of an inner circle of people who carried out the purpose of the so-called enterprise. Out of the 45 government witnesses, only 8 former employees testified. None offered testimony establishing personal knowledge of defendant purported illegal sexual conduct, let alone knowing felicitation of it. Despite repeated references of defendant's inner circle, which condones a small group of individuals close to the leader of a group, the government's enterprise evidence came largely from a handful of low-level employees. These employees were consistent of their accounts of working for the defendant. They largely just followed rules. Some arguably strange, but not inherently illegal. They were not privy to defendant's sex life or the details of his relationship. Most importantly, they never agreed to assist or help the defendant engage in illegal sexual conduct of any kind. Quite the opposite. The example, personal assistant Suzette and Alizette expressed concern about how defendant treated some of his live-in girlfriends, and both women worked for the defendant for a short period of time. Cheryl Mack quit her job the very next day after meeting Jane and observing her interacting with the defendant. The district court makes much of testimony that employees would sometimes pass defendant's phone number along to women. Not a single employee testified that they knowingly provided defendant's phone number to a minor or were asked. The record fails to show that there was an expectation to recruit underage girl or that any employee receive a benefit for doing so. Indeed, both Anthony Navarro and Tom Arnold denied ever providing defendant's phone number to underage girls or driving any woman who appears to be minors. In fact, the government's evidence revealed that employees were prohibited from interacting with defendant's girlfriend or talking about his relationship with them. Deronda testified that the defendant instructed her to continue to tell people that she was 19 after he learned she was 16. In short, the record is devoid of evidence that the member of the enterprise acted with the common objective to ensure that the defendant engaged in illegal sexual activity. Rather, the evidence shows that whatever illegal sexual activity in which the defendant engaged was concealed from his employee. He took measures to keep his personal sexual life secret. That some employees witness concern or odd conduct of defendant is not the same as sharing a common purpose to promote his illegal sexual conduct. Almost conceding the evidence of the enterprise was insufficient. The district court held that the government was not required to show common purpose of illegal or fraudulent activity as so as the person associated in fact share any common purpose, including the entirely legal purpose of promoting defendant's music and brand. Not so. As held in Satinwood, for the association of individual to constitute an enterprise, the individual must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purpose. Satinwood, Inc., and then give a case number on that. Clause and intercontinental exchange. Okay, these are all cases. Okay, let me keep going. As generally held that to constitute an enterprise, the association of individuals must share a common purpose to engage in fraudulent or illegal purpose of conduct. Thus, the government to prove an enterprise here, it was required to prove that the defendant and all members of the so-called associate in fact enterprise came together in the common purpose of recruiting women and girls to engage in illegal sexual activity, not merely the broad purpose of promoting defendant's music or brand. In an instructive case, Moss versus BMO Harris Bank, the plaintiff brought a putative action case against the First Premier Bank, alleging RICO violation. The plaintiff charged that FPB, a former legal entity, belonged to the Automated Clearinghouse Network, a payment processing system that processed unlawful ACH transactions on behalf of payday lenders. The plaintiffs argued inter alia that the ACH network constituted an enterprise consisting of originators, various depository financial institutions that receive ACH transaction instruction, ACH operators, and third-party service provider, all of which shared the common lawful purpose of facilitating batch processing of electronic payment for and between participating depository financial institutions. The court concluded that the ACH network described by the plaintiff did not constitute an enterprise for RICO purposes because it did not share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes, which was fatal to its claim. Emphasis on the original. New York versus Parcel Inc. Parcel Service Inc. All right, I gotta go down. Affirming dismissal of association. In fact, RICO claims were where the amended complainant admitted that certain participants in the purported enterprise were not aware of deceptive practices at issue. First, Nationwide Bank versus Gelt Funding Corp. Critically, the Moss court expressly rejected the plaintiff enterprise theory, finding it implausible that all the institutions that allegedly made up the enterprise possessed the unlawful intent required to transform that cooperative into association, in fact, enterprise for RICO purposes. ID 3 at 300. Let's go down. Dismissing the RICO claims that allege that the defendant used the Mortgage Electronic Registration System, MERS, to conceal unlawful mortgage transfer because plaintiff failed to show coordinated activity to jointly achieve a common fraudulent purpose. Emphasis in the original. The Moss court observed that at best, the defendant used a legitimate network to advance its own illegitimate business interests, and that the alleged illicit ACH transaction did not render the ACH network a RICO enterprise absent a common purpose among the other network participated to violate RICO ID. The Moss court's logic apply with full force here. The government's evidence showed at best that the defendant used his role within his legitimate music-driven collective to participate in private sexual misconduct. As in Moss, defendant's use of his otherwise legitimate music business to advance his allegedly illegitimate sexual need does not render defendant's business organization a RICO enterprise absent of common purpose among his associates to violate RICO. That defendant's employees shared an abstract purpose of promoting defendant music and brand does not satisfy the common purpose requirement, since there still must exist a nexus between the objective of the enterprise and the racketeering activity. and it's plain that the establishment of a RICO violation, there must also be some kind of relationship between the acts and the enterprise. For each of these substantive RICO subsection prohibited a specific type of interplay between a pattern of racketeering activity and the enterprise. See also Serenos and Petland Inc., holding that in abstract common purpose, such as a generally shared interest in making money, it will not suffice the establishment of an enterprise. Rather, where the participant ultimately purpose is to make money for themselves, a RICO plaintiff must plausibly allege that the participants share the purpose of enrichment themselves through a particular criminal course of conduct. See Ray versus Spirit Airline. Observing the common purpose of making money would not be sufficient to find an association in enterprise between Spirit Airline and outside vendors who merely provided anodyne services. Serum, whatever. I don't really know these names, y'all. Sorry. I'm being lazy now. In its order, the distinctive court claims that Satinwood is not at odd with Turcat, because Turcat mentioned nothing about a fraudulent course of conduct. Holding only the individual in an enterprise must share a common purpose to engage in a course of conduct. A closer look of Turcat strongly suggests that the Supreme Court presumed illegality of the course of conduct to which it referred. The question presented in the court in Turcat did not involve a deep dive into the course of conduct language, but addressed whether the enterprise encompassed both legitimate and illegitimate enterprise or is limited in application to the former. Turcat, the court rejected the argument that the entirely illegal organize was outside the purview of the RICO statute or inconsistent with the statute's purpose. The court wrote, on the contrary, these statements of purpose are in full accord with the proposition that the RICO is equally applicable to a criminal. Hold on, y'all. All right, guys. I'm sorry. Here we go. All right, there we go. The court wrote, let's go that. The court rejected the argument that an entirely illegal organization was outside the purview of the RICO statute or inconsistent with the statute purpose. The court wrote, on the contrary, that these statements of purpose are in accord with the proposition that RICO is equally applicable to a criminal enterprise that has no legitimate dimension or has yet to acquire ID. During its discussion, the Turquette assumed a RICO enterprise would have some criminal objective. The court compared those associations, in fact, that were entirely criminal in nature with those that were a mixed bag of criminality and legitimacy. Turquette never suggested that an enterprise could be established by individual engaging in a course of conduct with an entirely legal purpose and was unrelated to the alleged racketeering act of one person in the enterprise. The RICO statute was never intended to remedy criminal conduct of individuals who carried out their misdeed through the use of routine services by their underwitting personal assistant. Under the government and distinct district court's logic, the entire rogue actor working in an otherwise entirely legal organization can be prosecuted under RICO for merely duping his assistant or associate into facilitating his misdeed with mundane tasks. One could think of countless duties as of an unwitting personal assistant, such as making hotel reservation, calling an Uber, throwing out a bag of garbage, or delivering a message that could facilitate a criminal perpetrated by an individual working in the context of a business that does not a RICO enterprise make. B, defendant and the enterprise are not distinct. Relatedly, the government evidence of a RICO enterprise was insufficient because defendant is indistinct from the enterprise. For 1962, purpose, the person charged with a RICO violation and the alleged enterprise must be separate and distinct from one another. Cedric versus Kushner Promotion Ltd. versus King. Holding that one must and prove the existence of two distinct entities. One, a person, and two, an enterprise that is simply the same person referenced by a different name. This requirement flows from statutory mandated that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. Satinwood, Riverwoods, Chappaqua Corp, and Marine Midland Bank, Bennett versus U.S. Trust Company of New York, Brannon and Boatman, First National Bank of Oklahoma. An entity cannot simultaneously be the enterprise and the person who conducts its affair. Permitting that would be tantamount to permitting an entity to associate with itself. Bennett If, as the government claims, the objective of the enterprise was to promote the defendant and meet his personal needs, including his sexual activity, legal or not, the enterprise has no function unrelated to the defendant. They are one in the same. The government did not and seemingly could not indict a single other member of this enterprise under a RICO theory. Reflects the absence of an enterprise distinct from the from defendant. Since this RICO prosecution is the first of its kind and likely the last of its kind, this court must look to civil RICO cases for guidance. In Riverwood Supra, the plaintiff claimed that through acts of extortions and mail fraud, the defendant Marine Midland Bank coerced Riverwoods to reconstruct loan agreement between Riverwoods and Westchester Federal Savings. Later, acquired by Marine Midland, Riverwood, then it gave a case number on that. Riverwood purchased a property in Newcastle, New York, to develop residential condominium and obtain a loan from Westchester Federal Saving for the purpose. Marine Midland later acquired Westchester Federal Saving and inherited the loan agreement. According to Riverwood, shortly after acquisition, Marine Midland officers committed an intent to dishonor the loan agreement and engage in extortive behavior to force Riverwood to enter in a new loan agreement with terms more favorable to Marine Midland. In its complaint, Woodland alleged inter alia that through a pattern of racketeering activity, Marine Midland and two of its loan officers participated in the affairs of association in fact enterprise known as the Reconstruction Group in violation of 18 U.S.C. 1962C. The Second Circuit reiterated that under the plain language of the statute of RICO, person must conduct the affair of the RICO enterprise through a pattern of racketeering, and that the person and the enterprise referred to must be distinct. The court emphasized that a corporation entity may not be both the RICO person and the RICO enterprise, acknowledging that the distinctiveness requirement could be satisfied where there is partially overlapping between the RICO person and the RICO enterprise, and that a defendant may be a RICO person and one of the number of members of the RICO enterprise. Cited Cullen versus Magagiato, whatever the name is. However, by alleging a RICO enterprise that consists merely of a corporate defendant associate with its own employee or agent carrying the regular affairs of the defendant, the distinctiveness requirement may not be circumvented. ID. The Riverwood Court observed that because a corporation can only function through its employee and agent, any acts of the corporation can be viewed as such acts, such an enterprise. The enterprise is in reality no more than the defendant itself. See Bringingham versus Mobile Corp, where employees of a corporation associated together to commit a pattern of predicate acts in the course of their employment and on behalf of the corporation. The employees in association with the corporation do not form an enterprise distinct from the corporation. The Second Circuit reached a similar conclusion in Discon Inc. versus NYNEX, Nexus Corp. Their Discon Inc. was a New York corporation whose primary business was to provide removal service to telephone companies. Discon argued that the defendant, NYNEX, a holding company that controlled subsidiary MECO and NYTEL, New York Tel, collectively the next NYNEX defendant conspire with AT&T Technology to eliminate Discon from the market removal service by defrauding the public. Discon sued the New York Next, whatever the word, defendant with civil RICO, alleging that the NYNEX group, which consists of NYNEX, MECO, and NYTEL, were three separate corporate persons that conducted the affair of NYNEX Group enterprise through a number of illegal predicate acts. The Second Circuit observed that the distinctiveness requirement could not be circumvented by alleging a RICO enterprise that consists merely of corporate defendant associated with its own employees or agent carrying out regular affairs of the defendant. Relying on Riverwoods, the Second Court stated that where employees of a corporation associated together to commit a pattern of predicate acts in the course of their employment on behalf of the corporation, the employees and associates with the corporation do not form an enterprise distinct from corporation. The court observed that the defendant, Riverwood, NYNEX, MECO, and NYTEL operated within a unified corporate structure, and even though they were legally separate entities, the relationship between NYNEX, MECO, and NYTEL was not substantially different from that between the loan officer and in Riverwoods in comparison to the bank at 1064. In both cases, the individual defendants were acting within the scope of a single corporation structure, guided by a single corporate consciousness. See Atkinson and Anadarko Bank and Trust Company, with finding no enterprise distinct from the person where the defendant bank, its holding company, and three employees were not associated in any manner apart from the activities of the bank. Applying the rules of the foregoing cases, the government failed to prove an enterprise distinct from the defendant by alleging a RICO enterprise that consisted of defendant and his own employee agent carrying on his affair, namely promoting his brand, his music, and even assuming arguendo his sexual need. The government failed to satisfy the distinctiveness requirement. Put differently, because the government alleged that defendants' employee associated together for no purpose other than to carry out defendant's need, including his illegal sexual activity, the employees did not form an enterprise distinct from the defendant. Defendant and the alleged enterprise were one in the same. In sum, the government theories of a RICO enterprise was flawed, and from the start, the government's evidence taken in its best light showed only that defendant employed a collective of people over 25 years plus over his 25 plus years career, who promoted his career in his music. They did not share an objective to commit sexual crimes against women and girls. Accordingly, the government failed to prove an enterprise. The defendant racketeering conviction must be vacated. Number 2, the government evidence was insufficient to prove defendant guilty of violation of the Mann Act as to Jane. Defendant was convicted of violating the Mann Act in connection with his sexual contact with Jane during 2 separate trips to California in 2015. In its superseding indictment, the government charged that defendant violated the Mann Act pursuant to 18 U.S.C. 2421A when he arranged travel for Jane to California first in around April and May 2015 and again in October 2015 with the extent of exposing her to herpes, Racketeering Act 8A, 9A, and Count 2. Alternatively, the government charged that the defendant violated Mann Act pursuant 18 U.S.C. 2422A when he induced Jane to travel to California for the purpose of exposing her to herpes, Racketeering Act 8B. The government also charged that the defendant violated the Mann Act when he enticed Jane, a minor, to travel to California in September and October 2015 for the purpose of violating California Penal Law Section 261.5A and 261.5B, Racketeering Act 9A and 9D, and counts 3 and 4. A. Insufficient evidence of intent. Because the defendant motivating purpose in arranging the travel for Jane to accompany him on tour in California on both occasions has absolutely to do with exposing her to herpes. The government failed to prove 2421A violation of Mann Act. Similarly, defendant had no intention to induce or coerce Jane to travel to California to expose her to herpes, required by 2422A. Thus, Racketeering Act 8A, 8B, 9A, and Counts 2 must be vacated. Section 2421A provides that where whoever knowingly transport any individual in interstate or foreign commerce in any territory or possession of the United States with intent that such individual engaged in prostitution or any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisonment not more than 10 years or both. The government superseding indictment, Racketeering Act 8A and 9A, and Counts 2 charge that the sexual activity of which defendant could be charged for violating California Health and Safety Code 120290, which prohibits a defendant from willfully exposing someone to a contagious, infectious, and communicable disease. Seemingly, in this circuit, like others, To establish intent for 2421A purpose, the government must prove that a significant or motivating purpose behind the travel was to engage the individual in the charged illegal sexual activity. United States versus Miller. United States versus Soon Kim. United States versus Hayward. But C. Mortensen versus United States. Holden and that an intent must be dominant motive for such interstate movement. The illegal sexual activity must have been merely incidental to the trip. Under the significant of motivation purpose standard, the government's evidence of intent was insufficient because the record fails to show that the defendant intended to transport Jane to California at any time for the purpose of exposing her to herpes. The prohibited sexual activity charge. The government and the district court agrees that the purpose of the travel was not to expose Jane to herpes, but argued that the motivating purpose in bringing Jane to California was to have sex, and because those sexual activity could have resulted in defendant being charged in violating California code for failing to disclose his herpes diagnosis. The government's proof were adequate. This logic is gravely flawed as it reads the intent element entirely out of statute. A 2421, a violation of the Mann Act, punishes travel plus intent to commit a prohibitive sexual activity. In this case, the prohibited sexual activity is a violation of California public health law. The act is not so broad as to punish travel plus a violation of state law that result after the fact. Indeed, the United States Supreme Court held long ago in Martinasso and United States that the intent must be found to exist before the conclusion of interstate journey. United States versus Haslag. The crime began in a state where the defendant set out with the intent to cross state line and commit the crime. United States versus Griffith. Quoting Caminiti and United States. The purpose of the Mann Act was to punish the movement in interstate commerce of women and girls with a view to accomplishment of the unlawful purpose prohibited. The district court is simply wrong when it suggests that to satisfy the intent element, a general intent to engage in legal sex that ultimately could be charged for reasons entirely unrelated to the original intent of the travel satisfies the element of 2421A violation. Consider the hypothetical where a man arranged to have his adult paramour travel to another state for sexual purposes, but once there, she declines his sexual advances and sexual assault her. Under the district court's logic, this would constitute a Mann Act violation, which is decidedly is not. It surely would constitute a crime under California law, but not a Mann Act violation. A Mann Act was never intended to be a tool to punish violation of state law, particularly violation of public health law. The United States Supreme Court has warned courts to refrain from attributing a Congress to exercise of power to displace states in their traditional role of enforcing state criminal law. United States versus Lopez. With that established, the government simply did not prove that when defendant arranged for Jane to travel to California in either April 2015 or September 2015, he did so with a motivating purpose to expose her to herpes in violation of California Health Code. Similarly, defendant did not, as a matter of law, violated 2422A, where even if he induced Jane to travel to California in April 2015, did he argued infra? He didn't argue infra. It was not with the intent or purpose to expose her to herpes. The government's proof as to Racketeering Act 9D, Count 4, suffers from the same illogic, although adamantly at first blush, it appears to be a close call. The government alleged that the defendant transported Jane to California in September and October to engage in prohibited sexual activity, namely violation of California Penal Code Section 261.5A and 261.5B, unlawful sexual intercourse with a person under 18 years old. When defendant's sexual activity with Jane in California arguably could have been charged under California law, the fact remains that defendant's motivating purpose in bringing Jane to California on tour was not to violate California Penal Code prohibiting sexual activity with individual under the age of 18. Defendant and Jane had a consensual and legal relationship in Illinois. Defendant's purpose in traveling to California was to perform, and he arranged his girlfriend to go with him. Jane herself admitted that the reason for their travel was for him to perform at his show. That the defendant had his girlfriend with whom he was engaged in a consensual sexual relationship in Chicago accompanied him, not reflected intent to violate the prohibited sexual activity defined by the California law, state law. If defendant had sexual relationship with Jane in California in September and October, it was purely incidental to the purpose of the trip. Indeed, if defendant had not brought Jane with him, he likely and perhaps did bring one of the other live-in girlfriends on the trip as his companion. Sex was likely assumed respective of who defendant brought on his travel, which underscores that it was merely incidental to his travel, rather a motivating and significant purpose of it. At bottom, no nexus existed between the transportation of Jane and the alleged illegal sexual activity charged as as to any of the charged Mann Act violation. B, insufficient evidence of coercion and enticement. Separately, the government failed to prove a Mann Act violation pursuant to 18 U.S.C. where sufficient evidence existing to show the evidence knowingly persuaded. Let me go back. Separately, the government failed to prove a Mann Act violation pursuant to 18 U.S.C. 2422A, where insufficient evidence existing to show the defendant knowingly persuaded, induced, enticed, or coerced Jane to travel to California in April 2015 or September 2015. 1. April, May 2015, travel to California. The government evidence showed that the defendant invited Jane to come see his performance. See him perform in California after they commenced an intimate relationship in Florida. There was no inducement or enticement on the part of the defendant. Indeed, Jane's testimony and contemporaneous text messages between Jane and her mother reflect that at the direction of her mother, Jane deceived defendant about her age and carried out a plan to meet him and engage in a relationship, not the other way around. To be clear, defendant conceded that neither Jane nor her mother's conduct, no matter how troubling, would be a defense to this charge if defendant did in fact induce or entice Jane to travel to California for illegal sexual activity. But the evidence shows only that defendant invited Jane to travel to California to attend a concert, reasonably believing her to be 18 years of age, and she accepted. After attending one of defendant's performance, her parents in Orlando on April 11, 2015, Jane's mother obtained defendant's number and began communicating with defendant, posing as her daughter. Jane eventually communicated directly with the defendant via FaceTime and told him she was 18 years of age. Jane did not reveal her true age until months later. On April 20th, 2015, Jane's mother, still pretending to be Jane, arranged for Jane to meet defendant ostensibly to audition for the defendant. However, Jane and her mother were aware that the defendant, believing Jane to be 18, was also interested in Jane sexually. In one text, Jane's mother texts her daughter stating, "This man is trying to screw, but I'm trying to make it business." You see how she changed screw and she didn't want to say the word F. He knows you're a singer, but he ain't playing. Okay, she's saying it right now. He ain't playing. He wants to FT, fuck tonight. Despite that Jane and her mother were on notice that the defendant was interested in Jane sexually, Jane's mother encouraged Jane to entice the defendant. Be ready to sing 3 songs, and he said he will meet you and listen to your song. Please have your glasses off your hair. Glasses off hair to side. Mama knows best. Pretty hurts. And third, your choice, don't yell. Put on a show. Dance, grab his hand, shimmy, wiggle, sit on his lap, entice him while singing all about performance. It's all about performance. This your chance and opportunity. Don't blow it. Jane's mother even told Jane not to look grown. Emphasis added. After their first encounter, Jane and defendant continued to text at the encouragement of Jane's mother, and defendant eventually invited Jane if she wanted to attend his concert in California. Jane reported back to her mother, Jane, I talked to R. Kelly, Mom. Yeah, about what? Jane, LM, laughing my butt off about flying me out. Mom, oh really? When? Jane, yeah, whenever I tell him he can. Tomorrow if I choose. Mom, oh yeah? On April 28th, Jane traveled to Los Angeles, California to meet defendant with the knowledge and consent of her parents. At no point did Jane express her apprehension about being with the defendant and ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend his concert, Jane's mother responded, OMG, exciting you riding on the tour bus. On May 1st, 2015, Jane's mother urged Jane to take advantage of the defendant texting her, it won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he's tired of you, he'll be like everyone else. You better use this as your opportunity while you got him in spell. Jane's mother said, you should text him and be like, you know, you're gonna be my boo, and see what he says. To which Jane responded, laughing my ass off. Jane traveled with defendant from Los Angeles to Stockton, California, telling her mother, and he asked me, did I want to come to his show? I said, of course. And he said, okay, then let's pack this stuff up. He was putting his stuff in my bag. And Jane and her mother remain in constant communication before defendant's show. Jane's mother instructed her about what to wear and made suggestions on how she should behave at defendant's show. I would blow him little kisses and wink at him and bite the tip of my finger, mess with him real good. Do something seductive and then make silly faces. LOL. And Jane and her mother continued to text throughout defendant's performance. At one point, Jane's mother suggested that Jane would marry the defendant and that her son-in-law would be older than her, Jane's mother. According to Jane, she and the defendant had sexual intercourse for the first time after the concert. No rational jury could conclude that the defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's testimony, along with the contemporaneous conversation with her mother, shows the defendant invited Jane to join him, and she accepted. The government suggests that the defendant's mere act of arranging for Jane's travel is sufficient to demonstrate that he induced her to travel to California because he caused her to travel. The law says otherwise. The Circuit, the Second Circuit has made clear that the term persuade, induce, and persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meaning. United States versus Waqua. United States versus Gagalidia. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality, recognizes that there might be some uncertainty as to the precise demonstration between persuading, which is criminalized, and asking, which is not. Where the government conceded that the defendant was operating under reasonable belief that Jane was 18, Jane and her mother knew that the defendant was interested in Jane sexually from the jump street. The defendant merely invited Jane to meet him in California to attend a concert. The government failed to prove coercion and enticement. An invitation, even from the famous recording artist, is not persuasive, presumptually enticing or coercing. The government's evidence failed to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. She was invited, and she accepted at the encouragement of her mother, knowing full well that defendant had a sexual interest in Jane, who he believed to be of legal consenting age. October 2015 trip to California. The government charges the defendant with Mann Act violation of pursuant to 2422A and B under the separate theory that the defendant did knowingly and intentionally persuaded, induce, entice, and coerce Jane to engage in prohibited sexual activity under California Penal Law Section 261.5A and 261.5B. Unlawful sexual intercourse with a person under 18 in September 2015 and October 2015. As already discussed, the government failed to prove an intent to travel for the purpose of violating California's statutory rape law, where he was engaged in a legal sexual relationship with Jane in the state of Illinois. Furthermore, the government simply failed to prove that the defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California. Jane did not testify that the defendant took any action to persuade, induce, entice, or coerce her to engage in prohibited sexual activity while the two were in California as a result of his September/October 2015. Defendant and Jane were in a sexual relationship based primarily in Illinois, where defendant and Jane resided at that point. Although Jane testified that the defendant had already started engaging in controlling fashion, she did not testify that he coerced or enticed her to accompany him on tour. Jane traveled with the defendant to numerous states as one of his partners. She went consensually and voluntarily and remained defendant's partner until 2019. Defendant did not have to induce, persuade, entice, or coerce Jane to travel to California for prohibited sexual activity, even if Jane later characterized the relationship as abusive. The government's Mann Act theory were defective from the start, where the government distorted the purpose of the act and stretched its commerce power beyond all limits, making it difficult to imagine a scenario where the federal government could not exert its control into a traditional area of state control. The government's proof as a matter of law were insufficient, and this court must vacate defendant's conviction for racketeering acts 8 and 9, counts 2 through 5. Number 3. The government's evidence was insufficient to prove defendant guilty of violating the Mann Act as to faith. The government charged defendant with multiple violation of the Mann Act in connection with 2 sexual encounters with faith in New York. Specifically, the government charged defendant with violating 18 U.S.C. 2421 and 21A and 2422A in connection with sexual encounter that occurred in New York on May 18, 2017, Racketeering Act 12A and 12B, and count 6 and 7, and another encounter that occurred in February 2nd, 2018. Racketeering Act 14A and 14B, and counts 8 and 9. A. Insufficient evidence of intent. Racketeering Act 12A and 14A, counts 6 and 8, charged that the defendants transported Jane to New York on a separate occasion, May 18, 2017. 2017 and February 2nd, 2018, with the intent to engage her in sexual activity that would expose her to herpes in violation of New York Penal Law, Section NYPL 120.20, reckless endangerment, and Public Health Section 2307 NYPHL 2307, knowingly exposing of infectious venereal disease. Because there is no link connecting defendant's transportation of faith with an intent to expose her to herpes, defendant cannot, as a matter of law, be guilty of the charge 2421A violations. As discussed at length, the government must prove that the charged illegal sexual activity is sufficient or motivating purpose behind the transportation. Miller. Because the defendant purported violation of New York public health law prohibiting him from exposing a partner to herpes, and reckless endangerment was incidental to faith trip rather than motivating purpose in transporting faith to New York. The intent requirement of the statute cannot be sustained. As previously discussed, defendant must possess an intent to carry out the prohibited sexual conduct prior to travel. The government misled the jury concerning the law, which would explain why the jury retained guilty verdict on these counts, when it argued that defendant transported faith to New York for the purpose of sex. The only remaining issue is whether the sexual activity that he brought her here was illegal, or was it? This argument falsely suggested that the government only needed to show a general intent to transport faith to New York for sex, irrespective of whether he possessed an intent to engage in illegal sexual activity. As addressed Super. The government proves in Section 2421A by showing transportation plus intent to commit unlawful sexual activity, not intent to commit lawful sexual behavior that may result in illegal conduct. The government was required to show the motivating purpose behind defendant's transportation of Faith was to expose her to a venereal disease in violation of the specific offense charged. The same is true in connection with 2422A, offense where even if the government showed that the defendant persuaded, induced, enticed, or coerced Faith to travel to New York, his motivating purpose in doing so was not an intent to expose her to herpes. B. Insufficient evidence of coercion and enticement. Racketeering Act 12B, count 7, and 14B, count 9. Similarly, charged that defendant did knowingly and intentionally persuade, induce, entice, and coerce Faith to travel interstate commerce to engage in sexual activity that would expose her herpes violation of NYPL 120.20 and New York Public Health Law Section 2307. The government failed to prove that the defendant took any action to induce, persuade, entice, or coerce Faith into traveling to New York on May 18, 2017, and again on February 2nd, 2018. The defendant's mere status as a famous recording artist cannot satisfy the government burden to prove enticement and coercion. Rather, the undisputed evidence show only that the defendant invited an adult woman to meet in New York, and she accepted. In March 2017, Faith attended one of the defendant's concert in San Antonio, Texas, with her sister. Faith had an opportunity to meet the defendant at an after party backstage along with other individuals. Defendant and Faith had a conversation during the after party, and defendant provided her with his phone number. After the encounter, Faith and the defendant kept in touch via text and FaceTime. The conversations were normal, appropriate, and pleasant. Defendant complimented her appearance. Faith testified that the defendant referred to himself as Daddy during those conversations. According to Faith, defendant asked to be called by Daddy, and she agreed. Faith did not testify that the defendant forced her to call him Daddy. Indeed, defendant and Faith had met exactly one time when Faith began calling him Daddy. On the issue of travel, Faith had this to say. In your communication with the defendant, how, if at all, did the topic of traveling to come see him come up? Answer. He had informed me that he was on tour right now and excused me at the time he was on tour. So he was just saying his schedule was kind of crazy. But whenever I wanted to come see him, I could. And he said that could be arranged. Arrange the days and let him know when I wanted to come hang out. But it would be fun. I would get to see you and how it is. And how it is. How he is on tour. things like that. Defendant told Faith that if she wanted to come to his show, she could contact his assistant and he would arrange it for her. Faith then contacted defendant's assistant who made travel arrangement for her. Originally, Faith was going to travel to Chicago, but ultimately traveled to New York for the defendant's performance. According to Faith, defendant informed her that he was having a show in New York and that he would like her to come hang out. It was going to be fun. So I said yes. Defendant's assistant arranged her travel, and Faith traveled to New York to attend defendant's performance and hang out. Second Circuit has made clear that the term persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meaning. United States versus Waqua. United States versus Gagliardi. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality. Recognizing that there might be some uncertainty as to the precise demarcation between persuading and which is criminalized and asking which is not. No rational juror could conclude that Faith's testimony that the defendant coerced or enticed her travel to New York for the purpose of giving her herpes, no less. By Faith's account, defendant was polite, generous, and appropriate, leaving it entirely at her discretion to come to New York to attend a concert. Defendant's invitation did not equate to inducement or persuasion. C. New York Penal Code 120.20, reckless and endangerment. To the extent defendant's Mann Act conviction rests on violation of NYPL 120.20, the government failed to sustain its burden because unprotected sex with a person who carries the herpes virus does not establish a substantial risk of physical injury. No New York court has ever found as such. Indeed, at best, as defendant can tell, no one has ever been prosecuted in the state of New York for reckless endangerment of exposing a person to herpes who was not infected with herpes. Needless to say, the law on this issue is lacking. At the outset, Faith did not contract genital herpes. Faith claimed that some point in time after she visited New York, she was diagnosed with herpes type 1 after getting a cold sore on her mouth. She did not testify that she contracted genital herpes. There is no evidence that she did. Presumably, even the government would concede that cold sore caused by herpes type 1 and carried by 50% of the population does not cause a substantial risk of serious physical injury. Furthermore, as a matter of law, unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury. According to the city health department, 1 of 4 New Yorkers has genital herpes. if sexual intercourse with individual who merely carry the genital herpes carries virus, this essential risk of serious injury, physical injury. New York City would have astronomically hospitalization and date rate from transmission of herpes. Okay, let's go back up and read the. Okay, um, these are just website. Okay, let's go down. Although Dr. Hopkins, the government expert witness, identified some serious and unusual health risks associated with the contracting of genital herpes. The offense, the offense of recklessness endangerment requires a showing of a substantial risk of serious physical injury. To be clear, the defendant accepts that in a rare circumstance, someone afflicted with herpes could suffer serious physical injuries. But here, the government did not prove that face substantial risk of being infected with herpes and that a substantial risk that would suffer the rare complication that would satisfy the serious physical injury element. Dr. Hopkins estimated that there exists a 10% to 20% chance of risk of transmission when someone is managing their infection with Valtrex as defendant was. This hardly qualify as a high risk of transmitted the disease, nor does it consider that even low risk that someone who contract the disease will suffer a rare complication that qualifies as serious physical injury. Herpes is not deadly. It's treatable if not curable, and rarely cause any serious protracted health impairment. Complication associated with herpes carries a low or rather than substantial risk of seriousness. Serious health, physical injury as defined by the statute. The government cannot, as a matter of law, sustain this claim. In short, merely having unprotected sex with someone who carries the virus cannot, as a matter of law, create a substantial risk of 1, being infected with the disease, and 2, suffering the rare complication that qualifies as serious physical injury. The government cannot point to a single case that supports the prosecution's expansive reading of this statute. D. New York Public Health Law 2307. To the extent defendant's Mann Act conviction rests on violation of NYPHL 2307, the government failed to sustain its burden because there was no evidence presented at trial demonstrating that the defendant was infected with venereal disease during his sexual interaction with Faith, which explained why she never contracted genital herpes from the defendant. New York Public Health Law 2307 reads, Section 2307, venereal disease, person knowing himself to be infected, and any person who knowingly himself or herself be infected with an infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor. By the plain term of this antiquated provision, a defendant must know himself to be infected with an infectious venereal disease to violate the provision. The government and the district court interpret infected to mean merely carrying an infectious disease rather than having herpes related infection. The statute is silent on as to the definition of infected. The word infected in the statute must be interpreted to mean active infection to void constitutional concern. It is whatever the word is, whatever, must that most courts, state and federal, will generally interpret statute as to void constitutional difficulty. Expression hair design versus Schneiderman. As the evidence at trial shows, herpes is a virus that can constitute a venereal disease, but it does not follow the following virus equate to having an infection. That said, an active outbreak of herpes where someone expresses blisters, with someone experiencing blisters or open sores that would give them notice that they are contagious would qualify as an infection. The only logical and constitutional reading for the statute requires the government to show that the defendant was experiencing a herpes infection at the time of his sexual encounter with Faith, which would have put the defendant on notice of the possibility of transmitting the disease to a sexual partner. If this is not because the New Yorkers are violating the public law every minute of every day without any consequences. The government presented no evidence that the defendant was experiencing herpes-related infection during his sexual encounter with Faith, and Faith admitted that she did not contract genital herpes from the defendant. Accordingly, the government failed to prove the violation of NYPHL 2307. Number 4, because New York Public Health Code 2307 is unconstitutionally vague, the Defendant Mann Act conviction predicate on the law must be vacated. The government's Mann Act conviction as to Faith are predicate in part on his alleged violation of NYPHL 2307 discussed above. Prior to his trial, defendant unsuccessfully challenged the constitutionality of the law on due process ground. The Fifth Amendment provides that no person shall be deprived of any life, liberty, and property without due process of law. Johnson versus United States. In Johnson, the Supreme Court observed that our cases established that the government violates the guarantee by taking away someone's life, liberty, and property under the criminal law, so vague that it fails to give ordinary people fair notice of the conduct it punishes, or so standardless that it invites arbitrary enforcement. The prohibition. I don't know why I'm having a problem with this word right now. The prohibition of vagueness. I don't know why I'm having a problem. Of vagueness in criminal statute is a well-recognized requirement. I think I'm getting tired now. Constant, alike with ordinary notion of fair play and the settled rule of law, and a statute that flouts it. Violation of the first essential of due process. These Fifth Amendment principles apply to state law through the 14th Amendment. The Due Process Clause of the 14th Amendment requires that every criminal statute 1 gives a person an ordinary intelligence a reasonable opportunity to know what is prohibited, and 2 provide explicit standard of those who apply the statute. Dickerson and Napoleonanto, the plaintiff making a as applied challenge must show the statute in question provided insufficient notice that his or her behavior at issue was prohibited. Even if a person of ordinary intelligence has notice of what the statute prohibits, the statute nonetheless may be unconstitutionally vague if it authorizes or even encourages at I don't know attribute whatever and discriminatory enforcement of 747. New York Public Health Code 2307 failed both prolong of the Dickerson test by failing to define infection and including a mental state other than knowledge. The statute fails to put people of ordinary intelligence on notice of what conduct is prohibited. Furthermore, this court need to look no further than this case to see that the statute authorizes or encourages attribute. Oh my Lord. I don't know why I'm having a problem with this word. I know the word, but I'm having problems. And discriminatory enforcement. As best as the defendant can tell, he is the only person in New York history who has been prosecuted for violating this statute where the victim was not infected with the venereal disease. 1 in 6 Americans and 1 in 4 New Yorkers suffers from genital herpes simplex 2. As discussed previously, although herpes is not curable, there are highly effective treatment for herpes that prevent infection. Under the plain reading of this statute, even a person who carries the virus but who has been asymptomatic for decades would commit a crime by having sexual intercourse with another, irrespective of whether he disclosed his status to his or her partner. In the absence of a definition of infected, the statute is unconstitutionally vague. The government and the district court's interpretation of the statute is highly stigmatizing to millions of individuals who have been diagnosed with herpes simplex 2. The disease is easily treated and with the suppressive drug regimen, and people often experience complete remission from infection. While the district court assumed the infected meant having the virus rather than having the ability to transmit it, no authority support this application, and such an interpretation not only fails to appreciate how many people carries the virus, but would also lead to arbitrary and discriminatory enforcement. Indeed, under the government's interpretation of the status, it seems likely that every sexually active person in the statute of New York is routinely violating the statute. Human papillarium virus, HPV, is a sexually transmitted disease that, according to the Centers of Disease Control and Prevention, CDC, is so common that nearly all sexually active men and women get the virus at some point in their life. A person of ordinary intelligence would have no idea that they are prohibited from having sex in the state of New York if they have HPV, which would probably constitute 90% of the sexually active population. In sum, NYPHL 2307 is unconstitutionally vague, and this court must vacate the defendant Mann Act conviction to the extent that they rely on this unconstitutional vague statute. Number 5, defendant Mann Act conviction predicate on violation of California Health and Safety Code 120290 must be vacated because the government charged the defendant with a repealed version of the statute that was unconstitutionally vague. The government charged the defendant with several Mann Act violation predicate on defendant alleged violation of California Health Safety Code 120290. However, the government charged the defendant under repealed version of the statute no longer in effect. Prior to the jury charge in this case, defendant notified the court that the jury instruction did not reflect the elements of the California Health and Safety Code 120290. The government acknowledged as such, but argued that it charged defendant under the statute that was in effect in 2015, not the current statute. The government had no authority to charge defendant with a statute that was repealed and inoperative at the time of prosecution. United States versus Chamber. In a case a statute is repealed or rendered inoperable, no further proceeding can be had to enforce it in pending prosecution unless competent authority has kept the statute alive for that purpose. 2015 120290 of the California Health and Safety Code provided, except provided in section 120291 or in the case of the removal of an affected person in a manner the least dangerous to the public health, any person affected with any contagious, infectious, or communicable disease who willingly expose himself or herself to another person, and any person who is willingly expose another person affected in the disease to someone is guilty of a misdemeanor. The statute was overhauled entirely in 2018 after the California legislature determined that it was antiquated, having been passed during an era of discrimination towards those affected with HIV. The current statute bears little to no resemblance to the repealed 2015 version, least of all because it now requires showing a specific intent to transmit the disease. Although repealed, the government proposed a jury's instruction that reflected the elements of the statute in effect in 2015. Apparently, recognizing that the 2015 statute was constitutionally vague, the government included the elements in its jury instruction that were not included in the statute as written by the California legislator. Thus, the government not only charged the defendant with a repealed statute, but rewrote it in clear violation of various constitutional provisions, including the separation of power clause and principle of comity. Defendant's jury was instructed pursuant to a statute that never existed. A California court has no authority to rewrite a California statute, neither did a district court sitting in New York. Even if the government had the authority to charge the defendant under the 2015 version of 120290 of the California Health and Safety Code, the statute did not pass the constitutional muster. But most previously, the statute is void for the vagueness both on its face and as applied to the defendants, because it simply did not give person of ordinary intelligence a reasonable opportunity to know what is prohibited, nor did it provide explicit standards to those who apply for the statute. Dickerson. The statute also led itself to arbitrary, hold on a second, arbitrary, hold on, discriminatory, hold on a second, something's stuck here, hold on, sorry guys. Okay. Arbitrary discriminatory application. Again, defendant appears to be the first person in California's history to be charged under the statute where the alleged victim was not actually infected with the disease during the that occurred in California. As written, 2015, law failed to provide adequate definition about disease and the status meant to address when it criminalized willful exposure of all allegedly communicable diseases, including those not sexually transmitted. Statute is silent on what is meant by willful exposure and make sure no mention of whether the defendant could willfully expose someone to a disease without possessing the knowledge of his ability to transmit the disease, or without even knowing he or she has a disease. Indeed, it seems likely that the California legislature repealed this statute in part because its constitutional vagueness. Just as way of example, this statute would criminalize passing along coleslaw. Nearly 50% of the population has herpes type 1, a communicable disease under the 2015 statute. Anyone with herpes type 1, also known as coleslaw, who kisses another person will be guilty of a misdemeanor, even if the affected person has no active infection outbreaks and did not pass the disease along with the recipient of a kiss. Under this statute, parents with herpes simplex 1, again 50% of the population, would be prohibited from kissing their own children. One cannot imagine how many arbitrary prosecution could take place in this current era of pandemic if this law was in effect today. The example has shown this statute could be misused for arbitrary and discriminatory purposes. In its order, the government faults defendant through his trial counsel for failing to challenge the indictment or the constitutionality of the statute earlier. The reason is simply. Trial counsel had no idea that the government intended to charge the defendant pursuant to a repeal and inoperable statute. Although the indictment cites the statute and notes effective 1998, this language did not put defendant on notice that the government intended to charge him pursuant to the repeal version of the statute. Indeed, the first time trial counsel recognized the issue was prior to finalization of the jury instruction, when he objected to the government's proposed instruction that did not track the language of the current statute. Contrary to the district court view, the government cite to the California statute with the word effective 1998 did not alert the defense of its intent to charge a repealed statute. Indeed, it was entirely reasonable to assume that the government would not be charging a repeal statute that was clearly unconstitutional, as to the California legislature understand, but ENDY does not. Defendant has shown good cause for failing to raise the issue earlier. In sum, the Racketeering Act premised on, I'm sorry, Act premises on the violation of this repealed and otherwise unconstitutional status cannot stand. All right. Number 6. We almost finished, y'all. We almost finished. The government failed to prove defendant guilty of forced labor of Geronda and Faith based on the isolated sex act that neither victim alleged was false. The government alleged that the defendant committed the crime of forced labor when he directed Geronda and Faith to perform an act of oral sex on him on January 23rd in 2010 and January 13, 2018, respectively, where neither Geronda nor Faith characterized the isolated sex act as force. No rational juror could conclude that the defendant knowingly obtained or agreed to obtain any labor or service from them. These charges are yet another example of the government's transparent effort to stretch a statute far beyond its intended purpose to reach conduct that can no longer be reached by statute authority. A conviction of forced labor, 18 U.S.C. 1589, requires the government to prove beyond a reasonable doubt that 1. The defendant obtained the labor on services of another person, 2. Through inter alia threats of serious harm, and the defendant act knowingly. United States versus Marcus. The statute does not define labor of or services, but is given in ordinary meaning, i.e., labor means the expenditure of physical or mental effort, especially when figurative difficulty or compulsory, while service is defined as the performance of work commanded or paid by another. United States versus Marcus. Additionally, the government must establish a causal link between the labor and service provided by the person and the threat of serious harm. Section 1589 is intended to address serious trafficking or cases where trafficking threatened harm to third person, restraining their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. Marcharia versus Al Rohaf. The harm or threat of harm considered from the vantage point of a reasonable person is must be sufficient serious to compel that the person to remain in her condition of servitude when she otherwise would have left. According to the government, on January 2010, defendant violated the forced labor statute by using threat of violence to obtain labor or act of oral sex from Geronda. Accepting the government's evidence in its best light, Geronda described an isolated incident in which the defendant assaulted her because he was angry that she disrespected him. Geronda testified that after assault, she sat down with the defendant in a VIP room and he instructed her to perform oral sex on him. Geronda complied. Geronda did not testify that the defendant threatened her, forced her, or even demanded that she gives him oral sex. Geronda did not claim that she feared defendant would assault her again if she declined the request. Geronda did not even testify that she did not want to provide defendant oral sex. After the incident, Geronda left the defendant home of her own free will. Accepting Geronda's account as true, it simply does not establish the act of forced labor. An isolated act of oral sex does not qualify as labor or service. where there is no commercial aspect of the incident and the victim never testified that they expected any type of benefit from the act. Moreover, the record does not show that Geronda gave oral sex to the defendant out of fear or threat of violence. Notwithstanding the prior assaultive behavior, it would not have taken much for Geronda to make a casual link between the act of oral sex and her fear of physical assault by the defendant. But she simply didn't. The jury was not free to jump to such a conclusion in the absence of Geronda's testimony, particularly where this event was an isolated one. Similarly, no rational juror could conclude based on the evidence adduced at trial that the defendant knowingly obtained or agreed to obtain any labor or service from Faith on January 13, 2018, who testified that she traveled to Los Angeles to see the defendant with whom she had been having a romantic relationship. She described an incident where she and the defendant were in a small room in the studio. Faith claimed that there was a gun in the room. There was a gun in the room that made her intimidated, but concealed that the defendant never threatened her with it. But conceded that the defendant never threatened her with it or made any suggestion that he intended to use it. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him oral sex and grab her neck before placing his penis in her mouth. Without objection, Faith provided oral sex to defendant, although she testified that she did not want to. Faith herself refused to identify as someone who was forced to do anything. On cross-examination, Faith admitted that she was not a victim. She had made a choice to be with the defendant. Question. On the podcast we spoke about this morning, the paper route. On that show, you said during the interview, I don't like the word victim because I don't feel I am a victim. I am a young woman, and let's be clear. Let's be clear. I made a choice to be involved with that person. Do I feel like anything he did it was right? Hell no. But I had a choice, and that's why I walked away. I did not move in with him, and I did not live with him. I did not take any money from him. There was a choice that you have to make. You said that. Correct. Answer correct. Question. You made a choice. Answer correct. Question. You were not a victim. Answer correct. The forced labor statute was not enacted to remedy isolated occurrence like the one described by Faith. Indeed, it is not even clear from Faith's testimony that she communicated to defendant that she did not want to give him oral sex. She certainly did not end her relationship with the defendant after this episode. The record fails to reflect a casual link between the isolated act of oral sex and any threats of physical violence. Absent clear expression of congressional intent, court should resist the urge to transform the forced labor statute to cover the circumstance alleged in Racketeering Act 6, which bear virtually no resemblance of those paradigmic forced labor. And their victims. C. Chavari. Sorry, y'all. I'm getting messages from court describing prostitution, forced labor, sweatshop work, and forced domestic service as paradigmic forced labor cases. Joanna and Faith each described an isolated sex act with the defendant, and they now reviewed as assaultive. The district court contends that the jury was free to see these specific incidents as forced labor in light of other evidence it heard about defendant's conduct towards other women. But the government was not free to bootstrap testimony from other alleged victims to bolster their forced labor theories as a very specific act charged in the indictment. Geronda and Faith were not living in condition of servitude through threats of physical force. They each described as discrete acts that at best might have been charged as some type of sexual assault. And even that seems unlikely. To construe these events as fact of forced labor would render the purpose of the statute meaningless and force the federal government to free rein to charge any sex act accompanied by harsh or unkind words as forced labor. Number 7, defendant was denied fair and impartial jury, where several of the seated jury admitted that they prejudged the defendant's guilt, and trial counsel provided ineffective assistance to counsel when he failed to move the disqualified, apparently unqualified juror. As the United States Supreme Court Justice Black, I'm sorry, I'm scratching something. As the United States Supreme Court Justice Black stated in Re Michael, it is difficult to conceive a more effective obstruction of justice process when a juror who has prejudged the case. That is because due process means a juror capable and willingly to decide a case solely on evidence before it. And at trial, a trial ever watchful of prevent. Hold on, let me go back. And a trial ever watchful to prevent prejudicial occurrences and to determine the fact of such occurrence when they happen. Smith versus Phillips. The United States Supreme Court observed the right to a jury guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true regardless of the heinousness of the crime charged and the apparent guilt of the offender or the station in life which he occupied. A juror who has formed an opinion cannot be impartial. Enter citation omitted. In this case, the record shows that at a minimum, 4 of the seated jurors 3, 4, 5, and 12, were not qualified to serve. There were several other seated jurors who likely should have been struck for cause, but trial counsel failed to conduct a meaningful voir dire. Of these jurors to determine whether they could put aside their expressed bias and prejudice. Trial counsel performance was objectively unreasonable when he failed to move to disqualify patently unqualified jurors and failed to conduct a meaningful voir dire of prospective jurors who expressed their prejudgment of the case. Defendant was prejudiced by his counsel's substandard performance, where it resulted in the seating of at least 4 seated jurors who were actually biased and could not act with impartiality. Strickland versus Washington. United States versus Torres. Because of extraordinary pretrial publicity, the district court directed the parties to jointly prepare a jury questionnaire to probe into Leah prospective juror exposure to pretrial publicity. The court invited the parties to view the questionnaires in advance of jury selection and determine whether they could agree with a certain individual should be excluded for cause. After completing that process, the party was left to set a potential jury for oral voir dire procedures. The court gave both sides the opportunity to pose additional questions to prospective jurors. Inexplicably, defendants' counsel failed to challenge several jurors who ultimately sat on defendants' jury who were plainly incapable of serving as a fair and impartial jurors. Juror number 4, revealed in the questionnaire. Question 39. The charge in this case involved allegation of sexually exposed, allegation regarding exposure to one or more sexually transmitted disease. Is there anything about such an allegation you believe would affect your ability to serve as fair and impartial juror? Yes, I find Yes, I find transmission of STD in a non-consensual act to be particularly repulsive. Question 79. Which publicly known person do you least admire? Jeffrey Epstein. Although the court generally asks juror whether anything he or she reads would affect his or her ability to be fair and impartial in the case, the jury replied, "Not that I know of." Defense counsel failed to ask the juror ask the court to question the juror whether his feeling of repulsive about the transmitted sexual disease is a consensual scenario that would interfere with his or her ability to serve as a fair and impartial juror. The juror who expressly admitted that his or her feelings about non-consensual transmitted STD would affect his ability to be fair and impartial should have been struck for cause out of the gate. Inexplicably, the jury was not challenged or even questioned about his repulsion for the precise act for which defendant was charged. That same jury named Jeffrey Epstein as accused pedophile as the person he least admired, and is yet further supported by juror number 4, was not a jury who could serve with impartiality. Juror number 5 disclosed the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any special docuseries about him? Yes. What were your original impression? He loves underage girls. From what you've seen and heard, have you a general impression of the defendant? Somewhat negative. Wow, y'all. Why do you feel that way? Answer. The allegation related he was sleeping with underage girls, minor. Wow. Wow. Oh my goodness, that is terrible. Wow. Oh my goodness. Oh my God. All right, guys, I'm gonna give y'all about 30 minutes of my time. If not, y'all know, I think Dottie's reading this as well. So I'm gonna get off so I could take my butt on to my perspective stuff that I need to take care of. But let me finish reading this part. And if not, if you guys want me to read it later on, continue reading it, I'll read it when I come back from court. Y'all just let me know if you want me to read it, continue after this. Although the court asked the prospective juror a general question about her ability to put aside other things she might have heard, when asked if she could be fair, the juror indicated that she could give it a shot. Oh my God, she would give it a shot. The court reminded the juror that she had to be certain that she could consider only the evidence offered at trial. The juror begrudgingly acquitted. Even the district court expressed concern about juror number 5's ability to serve, observing, "So I don't know about you, but someone says they think they could do something in this context. I don't think it and qualified assurance, but I don't know what the party's position is that on that. I think I punished her pretty hard on it. I think I pushed her pretty hard on it, and we will still end up with, I think so. Let me hear from the government if you have a position on that." Not surprisingly, the governor was confident that the juror could be fair. The court still expressed doubt. Oh wow, the judge was not. Wait a minute, y'all. The judge even had a issue with that juror. The judge. Oh my God! Did y'all see that? Did you hear that? The judge was even saying after she pushed her, she still don't think, what's your position on this? And, of course, the government wanted that person. And the court expressed, this is the judge, the court expressed doubts. Explicitly, trial court agreed with the government and the juror was seated. The defense agreed with the prosecution. The judge had issue with it and the defense agreed with the prosecution. Wow. That was Tom Farinella, y'all. That was Tom Farinella that agreed, guys. That was Tom Farinella, and I'm going to call it out. I'm sorry. I'm going to call it out. That was Tom Farinella. That was Tom Farinella, y'all. Tom Farinella. Because he was the one that was doing the juror thing. And they try to blame. Kaenig had just came in. He wasn't even speaking on anything. It was Tom Farinella and Nicole that was the head of the thing then. Yep. The court still expressed doubt. See, the judge expressed doubt. You see, the judge expressed doubt. The trial counsel agreed with the government and the juror was seated. Trial counsel's performance was objectively unreasonable when he agreed to seating juror number 5, who not only watched Surviving R. Kelly, but concluded the defendant loves underage girls. When there can no trial strategy for failing to excuse this juror for cause. Had trial counsel challenged this juror, the court would have undoubtedly struck her for cause. She did. The judge did ask them, and they said they would seat her. All right? But I'm about to take my butt on. I'm on page 79. You guys let me know if y'all want to hear some more. But I'm about to get my butt on out of here because I got to get myself ready for court. All right? Darlings, I'm so sorry, but I've gave you as much as I could give you myself. And I will continue later on if you want me to. But right now, I got to go. I got work to do. Love you guys. I apologize, but I got to go. Let me know. Text me, email me if you want me to continue when I get back from court. All right. I'll see you later. Bye.